welcome to the first of this year's Caversham lectures, and it's on a topic that I have been wanting to know about and hear about for quite some time, because in recent years we've begun to live in quite dark times, and Parliament has rushed through a variety of legislation which has changed our liberties, our legal rights and our human rights, and it's been hard to know where we stand now. And finally I found somebody locally who knows a bunch of things about that and is a very good educator and communicator. So I'm waiting with great interest to hear. A personal note here, my son got very involved in, shall we say, extreme left-wing political activities in Otago, and I began to worry more and more as his activities became more and more interesting as to what I would do if he got into any more trouble. So his revolutionary fervour has abated now, and I have less concern on that front. But this is an issue that's of major interest to all of us. And I'm so grateful to Andrew to be leading off this year's Caversham lectures with such an interesting and important topic. So he's going to speak for about 35 to 40 minutes, and then there'll be time for questions. He does need to be away by 8:30, so we need to have our thinking caps on and be thinking hard about really good questions.
Well, thank you very much, Hugh, for the invitation to speak, and thank you for coming out and what sounds like it's going to turn into a terrible night, so hopefully by about 30 by the time we're leaving, the rain and the snow hasn't hit us. Anyway, I was asked by Hugh to talk about life with Big Brother, and I said, well, maybe we could put the question mark on there, just to, are we living under Big Brother? What is the situation here in New Zealand? The basic issue is, what is the power of the state to watch over us? So, I think we can all agree that the state does have an interest in keeping people safe, and the state does have an interest in identifying risks to us and to try to monitor those risks and to take action to stop those risks before people get hurt. And that's a perfectly valid thing for the state to do. And we need to look at things that have happened recently in the United States, New York, and the van attack there, the shootings in the church. If the state can step in and stop that from happening, that's to all our good. But at the same time, the state we can see represents something of a risk to us, a danger. There's a power imbalance in that the state can do a lot of things, has a lot of power, which if misused or used in the wrong way, it can badly affect individuals' lives. And so throughout this, there's always a balance. And the question is, where is that balance being drawn in New Zealand at the moment? So, our general right in New Zealand is found in Section 21 of the New Zealand Bill of Rights Act, Section 1990. It tells us everyone has the right to be secure against unreasonable search and seizure, whether of the person, property, or correspondence or otherwise. So that right says something about our relationship with the state, that we have a right, that it should be, that we can be safe in our homes and in ourselves from the state stepping in and interfering with us and our places unreasonably. And of course there, the key word is unreasonable. What exactly is this balance? Section 21 refers to searches and seizures. And it says they must be reasonable. What that means is two things. First of all, searches and seizures must be lawful. They must be permitted by law. And not only must they be lawful, but they must be conducted in a reasonable manner. So there's two steps to this. First of all, the state, before it can search or seize us, must have a power and law to do so. And then when it actually carries out that search or seizure, it must do so in a reasonable fashion. What then is a search? Because Section 21 of the Bill of Rights Act refers to searches. Now, we usually think of searches as being the classic, the police come to your door, knock on your door, it opens, they come into your house, they have a good look through your living room, your drawers, all those sorts of things. Or you're driving down the road and the siren goes behind you and your car is pulled over and the police come and they say, we'd like to have a little look through your car. Now those things certainly are searches. However, the right in Section 21 has been interpreted more widely to go beyond just those physical searches where the police actually come in and physically intrude into your space. And in a case called Hamid and the Queen back in 2011 in the New Zealand Supreme Court, this was the case that followed on from the Urewera raids. You may remember back a few years where the police were concerned that certain individuals were going into the Ureweras and were conducting what at the time were considered, quote, terrorism training camps. Well, the police in investigating those actions went on to land and placed a number of video cameras and still cameras to take pictures of what people were up to. And the question that then arose in this case of Hamid was, is using a video camera to record what people are up to on private land, is that a search? Because the police aren't there, they've put the video camera there and they've left, all they're doing is watching what is happening. And in the case of Hamid, Justice Blanchard, who was writing for the majority of the court, said if the police activity invades a reasonable expectation of privacy, then the activity is a search. So if the police or other state official does something that invades your reasonable expectation of privacy, then they're carrying out a search, and so the right in section 21 to be free from unreasonable searches applies. And in particular, Justice Blanchard stated, video surveillance may constitute a search depending upon the place which is the subject of the surveillance. In other words, if video cameras or other recording devices are being used in a way that invades your reasonable expectation of privacy, then it is a search and the right to be free from unreasonable searches applies. So that's the background right that we all enjoy. We have a right to be free from unreasonable searches and seizures by the state, where searches goes beyond simply the physical intrusion of the police or other agent of the state into your home or into your car. It also includes actions that the police or other agents may take that invade your reasonable expectation of privacy. Question then is, when can the state lawfully search you by watching or listening to you? Now, what I'm going to look at tonight is covert surveillance. That's where you don't know that a state agent is spying on you. You're being recorded and you don't know that you're being watched by a camera. You're being listened to and you don't know that the state is listening to your telephone calls, etc. I'm not going to talk about the power of the state to conduct physical searches where they actually come into your house and where they actually, physically look through your stuff. Partly that's because that area of law is simply a lot more complicated. There's just a lot more power for the state to do that. And also because if the state does that, they have to let you know they've done it. So if the state is coming into your house to search it, they have to give you the search warrant. They have to tell you this is what we're doing. Whereas, as we'll see, covert surveillance, where you're being watched by a video camera or listened to over the telephone, that happens without you knowing about, because the police are trying to see what you're up to without you being aware that you're being watched. So I'm going to be talking about this covert surveillance. First thing to note is that state agents, by state agents I mean people like the police, customs officers, fisheries officers, the SIS, as we'll see in a moment. State agents don't need special legal authority. They don't need any legal authority in law, any extra authority, to record what they see or hear if they're lawfully on your premises. So if the police come to your front door and knock on your door to ask you a question, let's say there's been a spate of burglaries in the area, and they come to your door to knock on your door to ask you, have you seen anything, have you heard anything? That's lawful for them to do that. They're just coming to ask you a question, and they happen to look through your window and they see something in your house that really shouldn't be there. Well, they can record that fact that they saw that thing there because they are lawfully on your property. Equally, if you invite the police onto your property, you ask them to come into your house, or you say, yes, it's okay for you to look around my house, and they record what they see there, once again, that's fine. They don't need any special legal authority for that. Equally, state agents don't need any special legal authority to record what you say to them in an interview or a conversation. whether or not you know you're talking to a police officer. So just in the same way as it is lawful for me to record my conversation tonight, right? I could have something on me recording my conversation with you tonight, and that's lawful, there's nothing illegal about that. A police officer can do the same thing. When they're talking with you, they're allowed to record what they say to you and what you say back to them. Equally, state agents can record you in a public place where you cannot reasonably expect privacy. So if you're walking down the street, the police are legally able to film you walking down the street because you've got no reasonable expectation that walking down the street is private. Anyone could be filming you while you walk down the street, so the police can do it as well. This also applies to the internet. If you're on the internet and you're writing things that are publicly available, open chat rooms on Facebook or whatever, the police are able to access that, look at it, record it. You have no expectation that what you say on the internet will be private if it's in an open source that anyone can access. And then finally, the police, state agents, can record you from a public place in your private areas for up to 3 hours a day or 8 hours total. So if your house can be seen from the street, the police are allowed to record it from the street, but only for up to 3 hours at a time and for no more than 8 hours total, without any other special legal permission. So all of those things are lawful for the police to carry out now, without any other authority whatsoever in law. Then, the police state agents can also get legislative powers to search you, to watch and listen to your activities in a situation you would expect as private, under two main pieces of legislation. The Search and Surveillance Act 2012, the Intelligence and Security Act 2017. The Search and Surveillance Act 2012 is the main one. This is the one that applies most broadly. What it does is it enables various state agencies, the police are one state agency, but other agencies can get this power as well, Ministry of Customs, fisheries officers, etc. State agencies can obtain a surveillance device warrant. And if they get a surveillance device warrant, that lawfully permits them to use an interception device, which essentially is a bug on your phone to listen to what you're saying to other people over your telephone, or it may be a bug placed in your car so that they can listen to what you're saying in the car, and so on. It also lawfully permits the use of a tracking device, a GPS thing that's put on your car so that they can see where you're driving to. They can see all the places you go to. Or it lawfully permits the use of a visual surveillance device, which is essentially a camera, to watch what you're doing in your house or around areas that you would expect to be private. So surveillance device warrants, you can see, give lawful authority to the police to do things that are very, very intrusive in people's lives. They can listen to anything someone's saying to anyone else. They can see where people are going. They can watch what people are doing in their own homes. And for this reason, surveillance device warrants are only issued for relatively serious matters. You can only get a surveillance device warrant if the police say that they're investigating or have good cause to suspect someone's involved in an offence which is punishable by a prison sentence of 7 years or more. Now, 7 years or more imprisonment is quite serious. These are fairly major crimes that we're talking about here. Or the police must have cause to suspect, good reason to suspect, that there is an offence relating to the illegal possession, use or supply of weapons. Restricted weapons. That's things like explosives, pistols, and so on. Just ordinary guns isn't enough to get a surveillance device warrant. It has to be, we think X has got dynamite, or we think X has got a pistol in his house. So this is a threshold that the police must meet. These are the sorts of things they can get such a warrant for. And such warrants must be issued by a judge of the district or high court. This again differs from ordinary search warrants. Ordinary search warrants can be issued by registrars of the court, who is, without being rude to any registrars, there are no registrars of the court present, are there? Registrars of the court are essentially just court officials. They're the people the clerks who run the court. They can't give these sorts of warrants. These sorts of warrants can only be given specifically by a judge, who must look at the evidence and say, yes, we think you, the police, are right when you say there's reason to suspect these offences are being committed. However, under the Search and Surveillance Act, state agents can use a surveillance device for up to 48 hours in certain emergency or urgent situations without having a warrant. Because of course getting a warrant requires bringing all your evidence together, filling out all your forms, putting them in front of a judge, getting the judge to look at it and sign it, and that all takes time. So the legislation says if there's a truly urgent or emergency situation involving a risk to life or very serious offending, 14 years of imprisonment or more, you can use a surveillance device for up to 48 hours before you get the warrant. And remember that the right in Section 21 of the Bill of Rights is a right to be free from unreasonable search. That right to be free from unreasonable search means that the search has to be lawful, the law must say it can take place, and it must also be carried out in a reasonable fashion. So if otherwise lawful surveillance is undertaken in an unreasonable manner, in other words, the police get a surveillance warrant which lawfully allows them to watch what people are doing or listen to people, but then they go about watching or listening in an unreasonable way, that will be a breach of Section 21 of the right, and thus unlawful. So an example, the police believe that someone is dealing Class A drugs out of a house. Serious matter, potentially could go to jail for a long, long time, up to life if they're importing the drugs. So the police get a surveillance warrant allowing them to place a camera inside the house to watch whether the person's dealing drugs. Can we see them dealing drugs in their house? The police then take that camera, or take several cameras, they put them in the living room, the kitchen, and in the bathroom watching the toilet. Now, sure, the police have a good reason to watch what's happening inside the house to see if drugs are being dealt, but they don't have a good reason to watch what people are doing in the toilet. So that might be an example of where a lawful power to conduct surveillance using video cameras is done in an unreasonable fashion. The police are simply watching things that they don't need to watch in order to catch the offending that they're seeking to catch. In that case, it would be an unreasonable search and it would still be unlawful. What then happens if the police conduct an unreasonable search? In this situation, what we're talking about, either they conduct video or recording surveillance without a warrant, or they get a warrant and then misuse the powers. They use it unreasonably. Well, one thing that may happen is that if the police use that surveillance to get evidence of wrongdoing, the court can exclude the evidence from any subsequent trial. It can say to the police, no, you misused your powers when you got this evidence, so you then can't use it in a subsequent trial to convict someone. That's a balancing judgment for the court to make. Is the breach of the person's right to be free from unreasonable search so significant that it warrants throwing out the evidence, even though that may mean someone who's guilty of a crime walks free? Second thing you can do is, of course, this doesn't help you if you haven't committed any crimes, right? If you're an innocent person and you've been surveilled, it's no use saying, well, we won't use the evidence because you haven't done anything wrong. So innocent people can also complain to the Independent Police Complaints Authority. And that body will then conduct an investigation, and if the police have misused their powers, it can issue a ruling and order an apology, which is very nice. It's always nice to have someone say sorry. Thirdly, it is possible for the courts to award damages if your rights under the Bill of Rights Act are breached. So if the police engage in an unreasonable search, that harms your rights. The courts can order the police to pay damages to make good your rights. You don't have a right to damages, the court will automatically give it to you, but it is possible to get them. And in fact, what tends to happen is, if unlawful surveillance has taken place, the police tend to offer a settlement. They say, look, yes, we're sorry, we shouldn't have done it, here's a couple of $1,000, $5,000 to make you go away. The second act I want to talk about is the very, very recent, just passed at the start of this year, Intelligence and Security Act 2017. This is the legislation that governs the Secret Intelligence Service. Security Intelligence Service. I always get this wrong. It's not the Secret Intelligence Service, it's the Security Intelligence Service. I have a relative who works for these people that gets very angry when they make this mistake. The Intelligence Security Act enables the Security Intelligence Service to obtain an intelligence warrant. Intelligence warrants authorize surveillance of individuals, including using surveillance devices, hidden video cameras. It authorizes the interception of communications, including using interception devices, bugging people's phones, listening to people's conversations in rooms and things like that. Intelligence warrants also authorize the Security Intelligence Service to covertly enter property, that is, go into people's houses without telling them they're doing so, to search them and to seize communications. Communications being documents, letters, computer hard drives, basically anything that can hold information. Now this last one is different to the power that the police can have under a search warrant. Where the police get the power to enter your house or your property with a search warrant, they have to tell you, they have to give you the warrant. When the Security Intelligence Service enters your house under an intelligence warrant, they don't tell you they've done it, because they're trying to spy on you. Right? There's not much point going into someone's house to spy on them if you then have to say, oh, by the way, we just searched your house. So these intelligence warrants, once again, give the Security Intelligence Service a lot of power to go into people's lives, areas where people would expect to be private, to find out a lot of stuff about people that they probably wouldn't want people to know. Who then can be subject to such warrants? When can the Security Intelligence Service get these warrants against people? Well, there are two kinds of warrants. There are Type 1 warrants, and these apply to New Zealand citizens or permanent residents. Type 2 warrants is everybody else. Type 1 warrants are much, much harder to get than Type 2 warrants. We're much, the way the Act is set up is, if you want to spy on a New Zealand citizen or permanent resident, the hurdles you have to get over are much higher than if you want to spy on a foreigner, basically. So the restrictions on Type 1 warrants, that is, warrants that apply to New Zealand citizens or permanent residents, these can only be issued by the Minister for the Security Intelligence Service, as well as the Commissioner of Intelligent Warrants, who is always an ex-High Court judge, working together. So the two of these people must both sign off on one of these warrants being granted. And Type 1 warrants, warrants to spy on New Zealand citizens or permanent residents, can only be issued for two purposes. One is to contribute to the protection of national security. The second is to contribute to New Zealand's international relations or economic well-being. And I'll talk about what these broad phrases mean now. So the first situation in which a Type 1 warrant can be granted is to contribute to the protection of national security. This requires specific harms to be imminent or believed to be in the air. And the threatened harm has to be something such as terrorism or violent extremism, or foreign spying, or sabotage, where sabotage has a very particular legal meaning. Sabotage isn't just damaging anything, it's damaging something that's critical to the nation's infrastructure. Or the threatened harm may be overseas serious crime. Not serious crime in New Zealand, but serious crime that involves overseas actors. And finally, threats to the New Zealand government. So before a Type 1 warrant can be granted for the purposes of contributing to the protection of national security, the Security Intelligence Service must bring to the Minister and the Commissioner of Intelligence Warrants evidence that one of these threatened harms is believed to be in the offing, and that in order to prevent one of these threatened harms, the Security Intelligence Service has to go in and engage in spying on the person involved by surveillance, intercepting communications, searching their house, etc., etc. The second grounds on which a Type 1 warrant can be sought and granted is to contribute to New Zealand's international relations or economic well-being. This requires not only that the warrant and the actions that will occur under the warrant, the surveillance, the actual spying, contribute to New Zealand's international relations or economic well-being, but also that the target of the warrant is acting for or on behalf of an overseas person or organisation. So you can only get a warrant, the Security Intelligence Service can only get a warrant under this, for this reason, if the person that they want to spy on is acting for someone outside of New Zealand. It's not enough for the Security Intelligence Service to show that we think this person is going to do something that may damage New Zealand's economic well-being. They must also show that that person is going to do that and that they're doing it on behalf of someone from outside of New Zealand. They're acting as an agent for a foreign government or a foreign organisation. So the Security Intelligence Service is really set up to either engage in surveillance, spying on New Zealand citizens or permanent residents, where those citizens or permanent residents are threatening one of these very serious harms, or where the New Zealand citizen or permanent resident is threatening economic well-being, international relations on behalf of a foreigner or a foreign entity. If a New Zealand citizen is threatening New Zealand's economic well-being on their own behalf or on behalf of another lot of New Zealanders, well, that's not enough to get a warrant. Equally, if a New Zealand citizen is going to be engaged in serious crime, that's not enough to get a Type 1 warrant unless the overseas crime is connected to an overseas, the crime is connected to an overseas person. Furthermore, the Security and Intelligence Act, Section 19, has this general protection for the right to protest in it. And this was inserted into the legislation deliberately by the government in order to try to combat fears that the security intelligence service would be used to target dissent or people who are just, protesting against the government's actions. And what it says is that the exercise by any person in New Zealand or any class of persons in New Zealand of their right to freedom of expression under the law, including the right to advocate, protest or dissent, does not of itself justify an intelligence and security agency taking any action in respect of that person. So if a person or a group of people is just engaged in dissent and is not engaged in any of those further serious harms, then the Security Intelligence Service can't have anything to do with them, is legally prohibited from being involved in any action towards them. Now that doesn't mean such people won't be spied on, it just means they'll be spied on by the police, not the Security Intelligence Service. There's then oversight of the Security Intelligence Service's activities. There's a specific office, the Inspector General of Intelligence and Security. Her job is to review the agency's compliance with the law. She runs a ruler over the Security Intelligence Service every year and makes sure that the warrants they're applying for have been applied for in the right circumstances, that they're obeying the rules under which they must operate. She also may inquire into and report on individual complaints about the agency's activities. I happen to know the person who's in this role, and she is impeccable without question. Speaking of ex-lefties, she was an ex-Trotskyite. She used to write, she wrote for the Trotskyist papers back in the late 1970s, early 1980s. She has good pedigree to do this job in that sense. There is also an Intelligence and Security Committee. This is a cross-party group of members of Parliament that the Security Intelligence Service must report to annually. So there's a group of politicians whose job, from all parties, whose job is to watch over the agency and make sure that they're not getting out of line, that they're not becoming a kind of rogue entity, operating on their own rules. That's as much as I was going to say about the power that the state agency has to spy on us under law. There is one thing I want to close on though, which is a grey area. And this perhaps was the area that, for me certainly, was the most concerning with regard to the state's powers towards individuals. The police in particular, but other state agencies as well, had a habit of going to places like banks, phone companies, car rental agencies and so on, and simply saying to those private companies, would you please give us information about person X that we're interested in? Not, here is a warrant, not, here is us legally compelling you to give us the information, but simply going into the bank and saying, look, we've got an interest in person X, why don't you let us have a look at their bank accounts? And the police and other agencies would then cite an exemption in the Privacy Act that allows people who hold private information, people like banks, people like your phone company, people like anyone you rent a car from, to disclose that information to the police for the purposes of maintenance of the law. So the police would say to a bank, we're investigating this person for an offence. It would really help us if you just gave us their bank details and everything they've been doing through the bank, without us having to get a warrant, and that will help us maintain the law. And banks and phone companies would then do it, would hand the information over. That, of course, is a problem because the person whose information was handed over, you never found out about it. The bank didn't come and tell you, you might be interested that we've just given all your bank details to the police. The phone company didn't tell the police, didn't tell you, we just handed the details of everyone you've talked to on the phone for the last 6 months to the police. And the police would then get that information without any lawful authority to do so. They would simply just ask for it, and if they were given it, well, more the good for them. The Privacy Commissioner has just released guidance on when this provision can be used, because this happened with regards to the journalist Nikki Harger and a couple of other people who since they found out about it and took the issue to the Privacy Commissioner, and the Privacy Commissioner has essentially wrapped the police and other agencies over the knuckles and said, you can't do this. You're misusing the exemption in the Privacy Act. The exemption in the Privacy Act has to be very carefully targeted so that the police can only ask for specific information where there's a specific offence or a specific crime they're investigating. They can't just walk into the bank and say, we've got suspicions about this person, it would help us if you gave it to us. And so the Privacy Commissioner has just released a set of guidelines to try to alert or to basically try to bring some sort of rigour to this process, and in particular to try to let agencies like banks and so on know that it's just not on for them to just hand information out like that in this way. So anyway, I thought I'd close on that grey area simply because it's something that's literally just happened, and I'm out of things to say, so I welcome questions.
You began by talking about the famous Uraweras case, and do I remember correctly that most of the people who were arrested and charged were not convicted, that the legislation was used against them was found to have, shall we say, holes in it, and it was intended to be used against external espionage rather than, shall we say, internal threat to this country? Are my memories correct on this one?
Short answer is it's slightly complicated. There's another piece of legislation I haven't talked about tonight, which is the Terrorism Suppression Act. And originally, when the Uraweera events were happening, one of the things that was cited by the police in justifying the investigation was this Terrorism Suppression Act. The Solicitor General, who's the government's top lawyer, looked at the police's claims about what people were doing under that act and essentially said that act is incoherent, which does not work when applied within New Zealand. It still works if, say, some New Zealander gets up and goes off to Syria and starts fighting for ISIS. The Terrorism Suppression Act would be used against that sort of person. But where you have a group of people in New Zealand who are up to nefarious no good, that Terrorism Suppression Act, it just doesn't work in that situation for legal reasons we don't need to go into. However, that doesn't mean that the people who were involved in the Uraweera stuff still hadn't committed other crimes under our Generic Crimes Act or under our Arms Act. And so those prosecutions still carried on. People were charged with various offences under the Crimes Act and under the Arms Act because they were running around with guns and they were alleged to be throwing Molotov cocktails and things like that, which is unlawful. But because of the Supreme Court's ruling that said all the video evidence that had been gained against them was unlawfully obtained, it was an unreasonable search, the police the court threw out most of that video evidence, said you can't use it because you've unlawfully obtained it. And without that video evidence, the police couldn't prove who was out there with guns and doing all these other various things, and therefore most of the charges fell away. There was only 4 people who'd been accused of particularly serious offences under the Arms Act. They were the only ones who ended up being convicted.
What about the .com situation? How did that come about, legally or illegally?
Illegally, because prior to this legislation, there was a prohibition on one of the government agencies, the GCSB, from using their surveillance capacities against New Zealanders. They weren't allowed to do it. It turned out .com was a New Zealand resident. They just hadn't realised that. And so this GCSB was using their power to intercept communications and so on against a New Zealand resident, and the law prior to this said you can't do it. So of course, what happened there was that the GCSB, the government has reached a settlement with .com and given him money for having unlawfully searched him, listened into him. They've now changed the law to say, actually, we are going to allow the Security Intelligence Services, the SIS and the GCSB, to use their powers to surveil on New Zealanders, but only in this situation, right? And the question would be, now, if you had another .com character come on shore, would his actions be such that would either meet this or meet that? And if they did, then he could be spied on using the SIS GCSB. But if they don't, they can't.
Thank you.
Yeah, is that?
That's fine, thank you.
Are state agencies able to act on information like the Paradise
Yes.
that are just dumped into the public domain? Are there restrictions on how they can act? I'm sure they can trawl through it, but are they able to act on that?
Yes, they would, if they could prove that the papers are actually what they say they are. I mean, so the issue there is even those papers have probably been unlawfully obtained because those papers, someone's leaked them out and probably in ways that are in breach of all sorts of confidence and so on and so on. But that doesn't mean the police, customs, tax people can't look through there and see what that information is and use that information in their own inquiries. But the problem is if you took that information into a court and tried to use it to prosecute someone, the defence lawyer would stand up and say, well, how do you know this is true? How do you know that this document that appears to show my client illegally sent all his taxes offshore hasn't been fabricated? So the authorities would have to independently corroborate anything that was in those papers. But they can certainly use those papers to start an investigation, to ask questions, to seek documents from a person and all those sorts of things. Yeah. And in fact, we saw an example of that with Nicky Harger's book, Dirty Politics, which was, of course, sourced from emails that had been stolen from someone, unlawfully stolen from someone, but all the stuff in that book was able to be used by any law enforcement agencies to investigate any potential criminal offending that may have taken place.
Do drones pose any particular issues in terms of surveillance? You have a drone flying around there, it's looking there for 10 seconds and then it buzzes off and looks somewhere else for 10 seconds. Is there a sort of cumulative time assessment of how long a drone is looking at a particular place or person?
Drones are very interesting. So, two things. One is that they may fall under the definition of, I have to go right back here, a visual surveillance device. So if the police want to use a drone to say fly over a property and watch what's happening in someone's backyard or something like that, if that is an unreasonable intrusion into someone's privacy, right, you've got a big fence around your backyard so it can't be seen by any means except by flying a drone over, you're clearly saying I don't want anyone looking in my backyard, then they would have to get a visual surveillance warrant to actually come and look into to use the drone. If they're using the drone just to fly over areas that are otherwise visible, in other words, you could stand on the road and look across a field when you're flying the drone across the field, then they probably don't need any authority, any extra authority to do so. So the question is not so much how can, are drones a problem, it's what sort of circumstances the drone being used. Is it being used to obtain surveillance of things that would otherwise be private and otherwise couldn't be seen? And if that's the case, then the police can only do so using one of these visual surveillance warrants. They have to get one of these special warrants to do it. Does that make sense?
Yeah. And just recently, having been observed with one of the observation of a drone, along with a whole lot of other people, not in this country, to a large extent I saw that as an invasion of my privacy. I was just going about touring actually, but here was this thing buzzing around and every now and then it'd have a close look at you and buzz off somewhere else and somewhere else.
Do you know who was operating it? Was it just a
it was in Russia, so...
Yeah, I agree, I hate the things, and I think we should have much tighter restrictions on them in general, but their use by the police wouldn't be any different from any other sort of video camera that the police are using. So in other words, if the police used a drone to follow you down the street or video your car going down the street, they don't need any authority to do that because they could sit in the car behind you and film you as you're driving down the street. But if they're using it to fly over your house and try to get, visual access of areas that you've deliberately closed off and don't want anyone looking at, well, that's an unreasonable intrusion into your privacy and can only be carried out using one of these warrants. So in other words, the fact that drones are annoying and that they're kind of, they're very obvious, to see them there, doesn't add anything to the lawfulness or not of the police using them.
So we'll see more of them.
Unfortunately, yeah, I think so. Yeah.
If there's a recording as a result of legal surveillance, but it doesn't result in a prosecution, do you know what happens to that
There are
recording?
time limits
There are
on
time
how long
limits.
it can be held, but it is quite long. It's up to 3 years. They can keep it on record, and that it's up to 3 years if there's a reasonable expectation that the case may kick off again. If you understand what I mean.
Mm.
So if they think, look, we haven't got enough, the case isn't quite going any further, we haven't got enough to prosecute, but if we got a little bit more we might prosecute, then they can keep it for those 3 years. And of course, they'll always find reasons to keep stuff running. I mean, it's just, the nature of the job is you don't want to throw anything out because in case it's useful one day.
The term reasonable makes me think of the old limited speed zones. If something goes wrong, you're wrong. And it's not actually the same thing.
No.
But reasonable is so open and flexible.
And it was deliberately left open and flexible for circumstances because, as we see, the right to be free from unreasonable searches and seizures covers everything from the police kicking your front door down and ransacking your house to flying a drone over your house and watching through to stopping. So there's so many circumstances that rather than try to micromanage everything down, the term unreasonable is just thrown out there, and then really it's left to the courts in the final analysis to either say, yes, this is okay, or no, it's not. And that does happen a lot. This right in the Bill of Rights Act is actually the most heavily used because it applies to the police interacting with individuals, many of whom they want to charge with criminal offences, and the question is, have they gathered the evidence from those people in ways that is reasonable or not?
Right, we'll draw it to a close there. Andrew, you spoke without notes, maintaining total eye contact with your audience, and you asked your subject very well, and there was no question that we asked that you could not immediately answer comprehensively, exhaustively, and interestingly.
You're shooting us a lot.
Well, of course. Thank you so much for coming out on tonight, and being both informative, elucidating, and very interesting.
Great.
Thank you.